Hello, Alistair Curry here for CPD On Demand, and today I'm talking to Sam Baleson, a legal advisor with Aon. Welcome, Sam.
Thank you, Alistair, and good morning to the viewers. It's an absolute pleasure to come and speak to you a little bit today about your legal risk and your liability exposure. I am part of the legal risk management team at Aon South Africa. We form part of a team of admitted attorneys that are here to give you legal and risk advice if you have a policy with Aon.
Fantastic, Sam. And today we're talking about a subject which is very close to your heart and a specialization within Aon, risk management. But risk management means a lot of things to different people, but how would you define it?
So, Alistair, I would say it is an absolute imperative process that a consultant, especially in the built environment, must consider.
Okay.
It is something that you must be proactive about. It is something that they must consider at the outset of a project, and it really is a process that one goes through of identifying their sources of risk. So what are their liability exposures? What are some of the ways that they can be sued? And also a process that they need to go through of identifying potential claims, avoiding those claims altogether, and mitigating the effect of a claim on their business. So what are some of the contractual processes and procedures that they can put in place that when a claim does hit, that they are somewhat protected in a contract?
Okay. But you bring something unique to the table in the sense that Aon offers a legal advisory service. Could you expand on that?
So our service really is unique. We specialize in our field. We really go through a process of looking at the legal risk and exposure of a client and giving them a hands-on service where we vet their contracts. We look at their agreements and we go through those contracts and say, these are your areas of risk. These are some of the things that could potentially prejudice your PI policy. This is what you need to be aware of. We are very proactive in that approach in that we serve on all major committees in the industry. So we serve on the CISA Quality and Risk Management Committee, the Supply Chain Management Committee and the Legal Forum, and even on an international basis. So we serve on the FIDIC Risk and Liability Committee. So we stay with our ears to the ground to understand the needs of the client and to understand the challenges being faced in the industry.
Excellent. Well, we're going to drill down into the details, and I suppose, Sam, at what stage of a project should risk management be considered?
Well, Alistair, it's absolutely imperative and important that a consultant consider their risks at the outset of a project.
Right.
So before you have commenced on site. We have large clients that are adamant about that and state that they will not commence on site and they will not commence with their designs until there is a written contract in place. They have considered their risk management, they have defined their contractual terms clearly, and they will not start on a project until that's done. And that really is the best approach to take.
It is.
But the reality is that in our space, it doesn't always happen that way. Sometimes we are only brought with a contract long after the fact, after a project has been completed or during that completion of the project. But the reality is that in this space, design flaws and mistakes often happen very soon after the fact. So if a claim is going to happen, it's generally going to happen either during the commencement of the project or very soon thereafter. And if one doesn't have a contract in place at that stage, they're exposed. So it's very important to set those checks and balances in as soon as possible before you start on a project, at least at your fee proposal stage, that you're defining your contractual terms there and then.
It seems obvious, but unfortunately people perhaps avoid something they know they should be doing because of cost constraints. Perhaps you could expand on cost of cover as opposed to the implications of not being covered in a risk situation.
Well, the reality is that to have an insurance policy in place is to the benefit of not only the consultant but also to the client. Because if a consultant that's doing work for you as a major client doesn't have a policy in place and they cause a catastrophe or a claim, you as the client are then going to have to liquidate that consultant's business. And are you really going to get a 200 million claim out of that consultant? I mean, consultants firms are made up of their intellectual property, really. So when liquidation happens, you're going to have to liquidate that business, sell off the couple of tables and chairs. Consultants generally don't even own the buildings that they work out of. They rent those spaces. So you're not going to get the value of that claim out of that consultant. Right. So it's to the benefit of the client and the consultant to have a policy in place.
Absolutely.
If a consultant doesn't have a policy in place, they risk the business, that they could potentially lose their business. So it's imperative to have that policy in place and to go through that exercise of checking what that would cost.
All right. Fantastic, Sam. So what are the various types of risk exposure? Could you run through those scenarios?
So, Alistair, the reality is that the space that we operate in the built environment is very adversarial. So there are many types of risk exposures that we have. And it's important to consider that at the outset of a project. The first one that I'd like to discuss is what's known as professional liability.
Okay.
And that is a very onerous duty that is placed on a professional. Generally, the court, when testing negligence, will use the yardstick of the reasonable man test to determine whether or not somebody was negligent or not. But in our space, when a person has a certain level of expertise or experience in a particular field, the court is going to hold them to a much higher standard. Something what is known as the reasonable expert test. Recently, the Harvard Business Law Review defined an expert as somebody that has more than 3,000 person hours of work in a particular field. Okay. Now, that is not a hard and fast rule or a yardstick that should be used. It's just a determining factor in determining whether or not somebody is an expert. But it is granted that a court will hold a professional to a higher standard. So it's very important for a consultant to consider that. The work that they are doing has the potential to be catastrophic. If a building or a bridge collapses, it could cause potential damage to third parties. People might lose their lives. So it's important to consider that they could potentially be exposed to that. And to know that the court is going to use that yardstick to measure their negligence. Right. It's also very important that when they are undertaking work in their personal capacity, so a consultant is doing pro bono or charity type work or what we know as moonlighting, that's fine. But the reality is that, number one, are they contracting correctly for that? Do they have the correct checks and balances in place? And are they insured for that work? Generally, insurance policies cover the company or the entity. So if you're doing work in your personal capacity, you're giving out advice at a braai or to a preschool or to your church, that's fine. But is it covered by the insurance policy, number one? And do you have a contract in place to protect yourself there? The next one that's so important is what's known as statutory liability. Okay. So statute is written law or legislation, an act. So let's take, for example, the Occupational Health and Safety Act, the construction regulations, pieces of legislation that determine who is to be held liable. The construction regulations are very specific in that they set out who on a project is liable for what and responsible for what. But what happens when an act is silent? When an act doesn't state who must be held liable? Generally, the sanction for non-compliance with a piece of legislation is a fine and a penalty or even imprisonment. Now, is a consultant considering that up front and accounting for those types of problems that they might face down the line? It's very important to think about these things and to be aware of them. When an act is silent, generally the court holds the professional liable. Again, going back to the reasonable expert test. Right. The next one is delictual liability. Okay. And the reason I want to discuss this is because in the absence of a contract, a consultant must never think that they can't be held liable. They absolutely can. Okay. Just because you don't have a written contract with somebody, just because they're not paying you a fee, doesn't mean they can't sue you. They can sue you, and the reality is that they're probably going to sue you via the law of delict. Okay. The law of delict, they're going to have to prove all 5 elements of a delict, which is not necessarily the easiest route to go, but the opportunity is there. Times have changed in South Africa. We are moving to what we know now as a more litigious society, like American legal systems, where litigants are able to access legal services on contingency fee basis,
Okay.
where they go to a lawyer and have access to that lawyer, and they only have to pay that lawyer if the lawyer wins their matter. So it's much easier to have access to that. So people are aware of their rights and they're able to approach a lawyer and sue. It's very important to consider that, because now you don't have a contract in place, you're being sued via the law of delict, and somebody is claiming from you that has access to a lawyer. So it's important to consider that you don't have a contract in place, your rights are unlimited. They can sue you for any amount that they can prove in court.
So we've spoken about statutory and we've spoken about delictual liability. Very complicated fields. And what about contractual liability? Can you expand on that for us, please?
Well, the reality is that it's always advisable in this industry, in the built environment industry and in the professional space, to have a contract in place, to have a written agreement in place. Again, the reality is that if you don't have a contract in place, you can still be sued. But when you have a contract in place, there are certain red flags and warnings that you must be aware of.
Okay.
It's very important that when you are presented with a contract, that you read that document, that you understand it. It's never a defense in court to say, I didn't understand the document, I was in a rush, I was on site, there were pressures, I couldn't read it and I didn't understand it, and therefore I just signed it to get on with the job. The reality is that a court again is going to hold you to that higher standard and say to you, well, if you didn't understand it, you, number one, should have consulted legal advice or legal opinion, and you should have read it and gone through it correctly. So always meticulously review that contract, and if you don't understand the complex legalese in that document, consult a legal advisor or a risk manager. The reality is that a court is always generally going to uphold a contract. It's very unlikely for a court not to enforce a contract. So if there is a contract in place, parties can't then decide that they do want to sue via the law of delict. They have to sue in terms of the contract. It's very important that when considering your contract, that you are not agreeing to things that you wouldn't ordinarily agree to if you were sitting across the table with your client and having a discussion.
Okay.
It's important that you're not agreeing to things that are going to prejudice your PI policy. So I'll give you an example where a consultant says, I guarantee that construction materials will be readily available at the time of construction, and they're not. And you're now held to account in terms of delay damages. What happens there is you have now agreed to a fine and penalty up front, and that's not picked up by the PI policy. Fit for purpose clauses, a very common trend in our industry. If you're signing those types of clauses, they are not covered by the PI policy, and you might even prejudice your cover on that. So it's very important to consult somebody that knows and understands your business, and also knows and understands your PI policy, because you could be prejudicing that. It's also very important for there to be consensus and for there to be a meeting of the minds. In the old days, especially in this industry, many retired engineers will tell me we had a handshake agreement. We sat across the table, we discussed our issues, and we just carried on with the job. A gentleman's agreement. But the reality is that in this space, in these times, we're facing litigious times, it's impossible to have that. And it's so important that when you have a contract in place, that you are considering those things up front.
Okay.
It's not a defense in court to say I didn't read a document. It's not a defense in court to say I didn't understand a contract. A court will uphold that contract, and you will be held bound by that. So that's very, very important.
Fantastic. So what's next on the list, Sam, in terms of risk exposure?
Okay, so some of the pitfalls of not entering into a written agreement is that you absolutely cannot protect your rights and limit your liabilities. When you don't have a contract in place, the delictual law will automatically be the way that a litigant sues you. But the reality is, in that space, you don't have access to limiting your rights and your liabilities. You're not protecting your best interests. And that's so important in a contract. There's sort of a myth or a rumor in our industry that it's absolutely illegal or it's unenforceable to have limitation of liability clauses in a contract. And that is absolutely not true. And we even have a judgment that's gone to the High Court. A consultant in Bloemfontein was taken to court for 30.5 million rand for design errors that he had done on a project. and the court upheld and enforced the limitation of liability clauses, and he was actually held liable for 2.5 million rand. So it's definitely enforceable, and we've seen that from this judgment. What's so important to note from that is that, number one, the consultant was largely underinsured for that 30.5 million rand, so he wouldn't have had enough cover to satisfy that anyway. So the client would have to liquidate the business and get the value of that claim out there. So it's very important to consider and balance the amount of insurance cover that you have in place to satisfy a judgment or a claim that might arise, and then balance that in line with limiting your liability correctly and adequately, and making sure that when you are limiting your liability, you are taking into account how much cover you have. Remember, our policies operate on what's known as a costs inclusive basis, which means that you do have access to legal and defense costs and VAT, which come off of your policy limit, and the balance thereafter is used to satisfy a claim. So it's very important that you're limiting your liability in line with the amount of cover that you might have in place.
So Sam, how can a consultant limit their liability? I mean, is it legal to do so?
It's definitely legal, Alistair, and it's very important. It is absolutely imperative that a consultant is considering this when they are looking at their agreements and when they are in that negotiation phase. There are two primary ways in which one limits their liability, and the first one really is in respect of quantum, the amount of money. It's done across the board in all standard form agreements, so your CISA, your PROXA, your CRDB, your NEC, those types of contracts all have these clauses written into them. And those are written into the contract in terms of quantum and duration. Quantum is the maximum amount of money that any of the parties can sue the other for. The standard industry norm there is generally 2 times fee, between 2 and 5, but it can be any amount. It can be limited to a multiple of one's fee, etc. We always say, government departments and certain large state-owned entities will insist that limitation of liability is unlimited or it's set at a very high value. At the end of the day, can the consultant really do anything about that? No. They can try and negotiate that, but the reality is always to try and consider that falls in line with the amount of insurance cover that you have in place, and some limitation is better than no limitation. The next one is in respect of duration. A client and a consultant can come to an agreement and say the maximum amount of time that either of us can sue the other for is limited to 3 years or to 5 years. Generally, that's the standard industry norm. That's very important because it's important to note how long you are maintaining your PI policy for. So our policies operate on what's known as a claims-made basis policy, which means the policy in place at the time a claim hits or arises is the policy that will respond. So if you don't have a policy in 15 years' time, you don't have cover for that. So that's very important when you're managing that risk to check how long do I need to maintain a policy at least for. When you are not limiting your liability in contract, the default position is the Prescription Act. Now, that is a piece of legislation that stipulates, very briefly, stipulates the maximum amount of time either of the parties can institute action is limited to 3 years. But that 3 years only starts running from the time a claimant becomes aware of the harm or suffers the harm. That might only happen 15 years down the line. So you design a bridge today and that bridge only collapses in 10 years' time. Prescription only starts running from that period of time. So there you would have had to maintain a policy for that extended period. It's very important to be able to manage that risk in contract up front. It is absolutely legal and enforceable to do that. We've even seen a recent matter that went to the High Court. A consultant in Bloemfontein was essentially sued for 30 million rand, and the court upheld his limitation of liability clause in the contract, which was for 2.5 million rand. What's so important there is that the consultant is exposed. If they don't have enough insurance cover in place, that client would have to come after them and liquidate their business, which could be catastrophic for a potential firm. So it's very important to write those clauses into the contract at the very get-go.
So Sam, it just gets more interesting as we go into this discussion. The next question was about agreements. How are they formed in South Africa?
Well, Alistair, the reality is that a court is always going to try and determine the common thread, and that is consensus. Was there a meeting of the minds? Did the parties come together to decide on a certain issue? Did they determine their rights and liabilities? Did they set that out? Now, there are various ways that a contract can be formed, and the first one that I discuss is what's known as tacitly. So that is basically by conduct, where parties act in accordance with how they want things to be rolled out. So let's take, for example, you walk into Pick and Pay on a Saturday and you purchase a loaf of bread. You take the bread off the shelf, you put it down on the counter, you pay, you get your receipt, and you walk out. That is a contract of sale. There are rights and obligations that are created from that and that flow from that.
Okay.
So just because you don't have a written contract in place doesn't mean a contract has not been formed.
Okay.
So that's the first one. The next one is what's known as a written contract. This is absolute first prize. This is what you want to have in place in our space because you can adequately define your rights, your obligations, you can limit your liability effectively. There is another way that you can form an agreement, and that is verbally. It's not ideal in our space because it's very difficult to prove in court. Okay. You have to get witnesses in to come and give testimony and to say what happened, and that can be considered as hearsay evidence. It's very difficult to prove in court. It's very difficult to uphold and enforce, and it's difficult to enforce your rights and your obligations and to limit your liability there, because how do you do that? That's why it's so important to have a written contract in place. But again, a court is always going to try and determine, was there consensus, was there an actual meeting of the minds between the parties, and did they act in accordance with that?
Okay, all right. So, I mean, we defined risk at the onset of the discussion, but are there some useful tips you can provide?
Well, definitely, and this is why it's so important to consider this at the outset of a project. My first tip is always read your documents. Know what you are signing, because you will be held bound to those documents. If you don't understand the documents that you're reading, you have access to legal risk services. You can consult a lawyer, you can consult a legal advisor to give you that expert advice. Sometimes these documents are written in the most complex legalese that don't make sense. It's not a defense in court to say I didn't understand the document. Consult the correct parties to give you the correct advice. It's always important to make sure that when you are looking at a document, don't just take it at face value. A client might present you with what's known as a standard form document, so a PROXA, a CISA, a CIDB document, a FIDIC document, and they've just ignored the copyright clauses in those documents and deleted and added to those documents what they like. Again, it's not a defense in court to say, I didn't see that they had deleted the limitation of liability clauses. So don't take things at face value. Read them, meticulously review them, and get that expert advice if you don't know what they are. And then also be very wary of client standard forms of agreement. When a client presents you with an agreement that their legal team has drafted, be careful of that. Remember, their legal teams are there to protect them and protect their rights. So make very sure that your rights are being adequately considered and protected. And also not to be rushed into signing a contract. Often a consultant will come to us and say, you know, the client presented me with this agreement and said they want it by tomorrow. Well, it didn't take them a day to put that document together. So you should at least be afforded adequate time to review that, to consult the correct parties to give you the correct advice, and to consider your rights and obligations in those documents.
Okay. Very interesting. And then we hear about this term counteroffers. I mean, what does that actually mean, and how do you deal with it if you're confronted with a situation?
Well, the reality is that a counteroffer is what happens when a client presents you with an initial offer, and they say to you, right, this is our contract, sign it. You then consult legal opinion, you go through the document, you consider it, and you say, right, I'm not happy with this document, I'm not signing it. You go back with what's known as a counteroffer. You add in your limitation of liability, you delete certain fines and penalties clauses, you say I can't agree to that because it's going to prejudice my policy, and so on. You then go back with your counteroffer. That offer is up in the air until the client actually accepts it. Often what happens is the consultant just carries on working on the project and they never get final feedback from the actual client. It's very important to manage that situation Because at the moment we don't have a written contract in place. Yes, you are acting in accordance with the document, but which document applies? It's very difficult to interpret that in a court. So be very clear on which document actually applies. Go back to your client and administratively manage the situation. Go back and say, and attach a red receipt to your emails and say, this is the document, my final document that I am acting in accordance with. If I haven't heard back from you within 10 business days, then I deem this to be the contract that is in place. And in 10 business days, follow up with the client.
So clearly, Sam, it's not a question of blind trust. One would be foolish to do that. One should go through the full legal process. But from what I'm understanding here, there are common situations where contracts start while counter-offers are still being discussed, which is clearly not advisable.
Definitely, and it's a very common trend in this industry that consultants are commencing on a job once a project has already started and they have no document in place. Again, what happens generally is that these claims, if they are going to arise, if design flaws and errors are going to come up, that generally happens in a very short space of time. So usually during the project or very soon thereafter. And if we don't have a contract in place, your rights are not adequately protected there. So when you are making a counter offer or a client is making a counter offer back to you, it's very important to make sure that both parties are aware of which document actually applies. So to administratively manage that process.
All right. If a contract hasn't been signed, you did discuss about the expert as opposed to the common law. I mean, would the common law apply in any instance?
So again, what would happen is, in the absence of a contract, if there's no signed or written document in place, generally the common law would apply, and generally the party suing would sue via the law of delict. It's very important that when we don't have a written contract in place, we're aware of the fact that we are completely exposed. Our limitation of liability clauses are not in there. We haven't adequately protected ourselves. It's very difficult to try and uphold a document in court that hasn't actually been signed. You might be able to prove that you acted in accordance with that document. Both parties had a copy of that document, but it wasn't actually signed. But it's a very, very far-fetched route to go. You don't want to be in that position fighting in court for 2 days on determining which contract applies. Rather have a signed contract document in place. Both parties are very clear on this is the document that applies.
Absolutely. Okay. So obviously on a team, you're the lead consultant, the lead contractor, whatever it happens to be, but there are sub-consultants involved. So what do we do then, or what would you recommend in terms of managing exposure?
Well, it's very important for a consultant to consider their risk exposure there. Generally what happens in terms of projects is a client will appoint a main consultant or a consultant. That consultant, because they either don't have capacity or they don't have the skill to take on other disciplines of work, they will then subcontract or subconsult that work down. Now, the reality is that the legal relationship exists between the main client, your client, and then between you. So that is the parties that are entering into a contractual relationship. You are then entering into a relationship with your sub-consultant. So if that sub-consultant in effect causes a claim, you are then liable for that claim. And the client is going to come after you, not the sub-consultant. So it's very important to make sure you know who you are appointing. Make sure you know who you are doing business with. Make sure that they are suitably qualified to undertake the work that you are appointing for them, because you assume liability for them.
All right, so in most situations there are sub-consultants, subcontractors involved. And for the main contractor there's a responsibility. How does one manage exposure in that situation?
Well, it's very important for a consultant to consider the types of liability that they're exposed to in that space. And the reason for that is ultimately they have a contractual relationship with their client. Their client has appointed them, and they have in turn then made sub-appointments and appointed other parties. There is no contractual link between the client and the sub-consultant. The consultant remains ultimately responsible and liable for those appointments that he or she makes. So it is very important for a subby or a sub-consultant to make sure that they have the correct and adequate insurances in place. And it's important for the consultant who is appointing that subby to make sure that those insurances and those checks and balances are actually in place and the correct contracts are also in place. Ultimately, what will happen if there is a claim, the client will come after the consultant, and the consultant will then in turn have a right of recourse against the sub-consultant that he or she appointed. Now, in terms of our insurance policies, you are covered for your appointment of that sub-consultant, but there are conditions to that. You have to make sure that the sub-consultants that you appoint are, number one, suitably qualified to do the work. So if they say that they're a civil engineer, make sure that they are in fact a civil engineer. And also just to make sure that they have their own adequate insurance policies in place. Because what will happen is your policy as a consultant will respond, but it will try and seek right of recourse against that sub-consultant's policy. If they don't have a policy in place, their business or that sub-consultant's business will have to be liquidated. And you're not going to get any value out of that because if there's a 200 million rand claim, you're not going to get that out of liquidating a small sub-consultancy business. So it's very important to consider that and to have those contracts and checks and balances in place long before the work commences on a project, because there is that exposure and that liability. It's also very important to consider in what capacity you are being appointed from your client. So if the client is appointing you as principal agent, you are acting as the client's advisor, and it's very important that that is very clear in contract. And it's not sort of an assumed liability that you're just taking on in terms of that project. It's very important to have all of this documented and to have the correct contracts in place to protect yourself and to protect yourself from any potential claims that might arise.
Okay, so you've always got professional indemnity in place, but for each project you should also have a tailor-made policy to protect yourself. Is that correct?
Well, the reality is that yes, it's important for a consultant to have their own PI policy in place to protect themselves.
Right.
The client can decide to take out principal controlled insurance to sort of cover the entire design team.
Okay.
Yes, that does happen.
Right.
It's not necessarily the case. It doesn't have to happen that way.
Right.
At the end of the day, the consultant needs to consider their risk, their liability, their exposure. Are they covered? They would have their PI policy in place, and if there is a principal control policy in place, that is completely fine. But it's very important for the consultant to notify their broker of that situation.
Right.
So technically, it's a general rule of insurance that you can't have two policies covering the same risk.
Okay.
So it's important to note that and to make sure that that is noted on the policy, because then there'll be a fight at claim stage as to which policy pays out on this claim. There are certain things that a project-specific or principal control policy doesn't necessarily cover. So, for example, consequential losses and cost overruns. So the PI policy will come in and act as a difference in limits and difference in conditions policy there. And generally will cover the deductible of that bigger, broader project or that policy. It's important to note that from the get-go, and to also make sure that you are limiting your liability correctly there and you are contracting correctly as well.
Exactly. Fantastic. So, building on from this, what can we say about joint ventures?
Well, the reality again is that in our space it's a very common type of appointment. So a client will come to a consultant and say, I want you to do X, Y, and Z. And you just don't either have the capacity or the skills. And you decide now that you're going to form a joint venture with other suitably qualified people to provide the end product to the client. Now, there's liability and risk exposure from that. So in terms of a joint venture or a consortium type agreement, what will happen is parties come together to form a relationship and provide an end product to their client. There is joint and several liability that flows from that. Okay. What that means is that any one of those parties to the JV can be held liable for the work of another consultant. They then have the opportunity to seek right of recourse against the actual guilty party, but that's not the client's problem. That becomes each member of the JV's problem. So it's very important to structure that relationship correctly. There are two ways that a JV or a joint venture can be formed, and the first way is an incorporated joint venture. That is a more formalized process where parties come together and they actually register that entity as a separate legal entity or like a company. And what that means is that generally they take out, they ring fence the risk, and they take out a policy to cover that JV.
Right.
The other way of doing it is more of an informal way, an unincorporated joint venture, where parties come together, they form a relationship. It's not a separate legal entity. They might give it a name, but they just come together to perform services or end services for a client. There is still joint and several liability that flows from that. So the important considerations there to make are, number one, know who you are doing business with. Know who you are entering into these relationships with, because you are potentially assuming liability for them. You could be sued for their mistakes. Number two, make sure that they have their own and adequate insurances in place. Again, the insurers will defend you and they will provide the legal defense costs to get you out of the trouble. And they cover you for your participation in that joint venture. But at the end of the day, if you are held liable for the claim, which you could be, it will sit on your policy, or insurers will repudiate that claim.
Okay.
So it's very important that those other parties have their own policies to cover for that risk should insurers seek right of recourse to recover those losses, which they're entitled to do. And then also, just to make absolutely sure that you are contracting correctly, that the correct contracts, checks and balances are in place before that relationship begins and before you start performing on a project and providing those services.
Right. Sam, we talk about dispute resolution mechanisms. Is it important to specify alternative options in the contract?
Well, definitely, and we're seeing this more so happening very often on projects in our space, and we are seeing trends where legal fees on a dispute or on a claim are coming to at least between 35 and 40% of a claim. Okay. So it's taking a large chunk of that policy limit out. And for that reason, it's very important to write those alternative dispute resolution clauses into a contract, because you are spending so much time and money on legal fees and defending yourself and fighting those legal disputes. Also, often in terms of our space and in terms of construction type projects and design type projects, often parties just want to get on with the job. They just want to get back on site and complete the services, because there are very restricted timelines to getting those projects completed. How do you do that when you're waiting a year or 2 years for a trial date in a court? It's very difficult. Also, in terms of arbitration, yes, it's not necessarily cheaper, but it is quicker. Most of the time it is quicker. And also you have an expert determining your matter. So parties can determine in their contract who decides their matter. Is it a retired engineer? Is it a retired architect? And so on. Somebody with expertise in that field that can have insight into that matter and come in and give an impartial decision and finding. You have the more informal routes that you can go, so negotiated settlements or mediation, where parties come together to reach a decision and to make a determination. It's more of an informal, unbinding process. A mediator comes in to just facilitate that process. That's opposed to your adjudication and your arbitration, which is more of a formal process where you have somebody coming in to make a determination. It can be binding and final, determined, which is determined by what is written into the contract. So parties can decide whether or not they want the opportunity to be able to appeal that to a court later on.
If they decide. All right, so throughout this discussion, it's becoming clearer that legal advice is absolutely essential. So a point now is about cover, because we've been speaking about contracts and the law. Now we're talking about certain insurance mechanisms, and the one that I wanted to ask you about is this costs inclusive policy. What is this exactly, Sam?
Well, the reality is that our policies do operate on what's known as a cost inclusive policy, which means that you have access to legal defense costs up front, Legal fees and VAT come off of the policy limit that you select, your limit of indemnity or amount of cover that you have in place for any one claim that might arise. But legal fees and defence costs do come off of that, and so does VAT.
All right.
That is very important for a consultant to consider, for the mere fact that when a claim happens and when they are limiting their liability, that they are taking that into account. When they are selecting the amount of cover that they have in place, that they take that into account. When a dispute happens, legal fees of around anything between 35 to 40% of that claim might go on legal fees. And then you've got your Section 8.8 15% VAT that's going to come off of that, and only the balance thereafter will be used to satisfy the claim. So when you are limiting your liability, you are taking that into account and considering that upfront.
Okay. All right, Sam. Well, I want to thank you for really excellent discussion. What would you say in summary for our viewers out there?
Well, it's absolutely so important and imperative to consider your risk, to think about your risk, to think about it at the correct time of a project, at the very outset of that project, and also to develop the skill of being able to negotiate with your clients and enter into those constructive discussions. To be able to sit with your client and say, I cannot agree to these clauses. Number one, it's not fair for me to take on more risk than I'm being rewarded for on a project. And number two, this could potentially prejudice my PI policy or my insurance policy, which would have a knock-on detrimental effect for you as the client. So to be able to have those informed discussions and negotiations with a client. To be able to understand your risk exposure and the environment that you operate in. If you are operating in different jurisdictions, to understand the laws that you operate in terms of those countries, to understand the types of exposures that you have in terms of your own country. What are some of the regulations and some of the acts that apply to you? Construction regulations, the OSH Act, and so on. And how can you be held liable there? To consider those risks, to consider those exposures as soon as possible from the get-go before you commencing on a project. To make sure that when a claim does happen, if you can't completely avoid that claim, that you have protected yourself adequately in a contract, managed your risk, managed your liability, protected yourself, limited your liability upfront in that contract.
Excellent, Sam. Thank you so much. This is Alice Sakari for CPD On Demand.